reflect the presence of counsel and parties. Straub.
Thank you, Your Honor. May it please the Court. This lawsuit should really be viewed in the context of a larger public records request. And I think that's important for a number of reasons. The public records request that this lawsuit arose out of came in January of this year. And it was made by the Democratic Party, and it requested 10 different classes of documents, many of them computer files, including the files that we're really here to talk about. What we turned over to the Democratic Party were things like Windows event logs, GEMS audit logs, directory listings, extensive amounts of information that would help the Democratic Party or others, and I want to make that clear, others, anybody who would be interested in this, because this isn't just about the Democratic Party, it's about everybody's ability to access public records. And to be able to determine what is happening in our electronic voting system. The county chose not to turn over these particular files, the .mbd, the .gbf files, because those files contain sensitive information about the conduct of elections, the real nitty-gritty. Or as Jim March would like to say in an exhibit that he would certainly attest to, I'm sure, the crown jewels when it comes to the analysis of how elections are set up in electronic voting systems. Mr. Reisner is giving you a long opening statement. It'd be a great statement to make on the floor of the legislature. It is not a statement, though, that I believe that is necessary or appropriate for the disposition of this particular lawsuit, or at least many of the items in that. The issues in this case are whether the requested files, first, are public records. Second, whether, if they are public records, are they nevertheless rendered confidential by ARS 16645D. And finally, even if the court were to find that they are not confidential, whether their release would nevertheless be detrimental to the best interest of the state or the best interest of the government, as that concept is understood in Carlson versus Pima County. As a start of this, the court, and what we've turned over to the court has an independent role, certainly, with respect to initial analyses of the records. And I just want to get one housekeeping thing out of the way before I move into my more substantive arguments. We have disclosed for in-camera inspection a true copy of an elections database. That's a copy of what is down, you have in the vault already. And that has been loaded on to a machine, a computer, that has been loaded with both GEMS, that's the Global Election Management System that Pima County uses, and it's our current version of GEMS. It's a system that's used by 11 other Arizona counties. And we've also enclosed instructions for the court to access the database. Again, those are in camera, and I've gone through those instructions such to ensure that there is no advocacy in the instructions. But if there's an issue with that, I think we can address that. But it would allow the court to make an independent investigation of the records. And that independent investigation is something that our Supreme Court recently, in its new ever-evolving approach to questions of public records, has asked the courts to do as an initial matter, examine the records in camera to determine whether or not they are public records. And that analysis is under Griffiths versus Pima County, which is a 2007 Arizona Supreme Court case, and also Phoenix Newspapers versus Ellis. The county's position is, with respect to whether or not these are public records, that the computer program that creates the election, and particularly the programmatic elements of the requested NBD and GBF files, are not public records in this traditional sense, particularly when the relevant statute, 16445D, does not appear to treat them as such. If we cross the threshold and the court determines, obviously, that these are public records, at that point, we would then have a discussion as to whether they're confidential under law. And it's our position that there are 3 reasons why we believe the law makes them confidential. First, the files at issue contain SQL programming code, and therefore meet the industry standard definition of computer program. That is, I'm not saying the whole file is a computer program. The elements that we're trying to protect have that SQL programming code. That is an admitted fact. That's admission number 8 to our request for admission, we found in exhibit number 4. Second, because the files are necessary to count the ballots at an equivalent processing center, they meet the legislature's definition of computer program under 16444A4, which definition is incorporated into the confidentiality provisions of 445. Finally, these files meet the Secretary of State's interpretation and definition of computer election program in its duly adopted elections procedures manual, which specifically interprets section 16445D. Now, we're going to present some evidence. Let's go through each of these quickly. I think Mr. Reisner said it right when he said, and I'm talking about the industry standard for computer program, that people could change the instructions in the database and therefore change the results. I thought that was telling, because that's the definition of a computer program. A computer program is a set of instructions that tells a machine what it's supposed to do, where it's to send data, what it's supposed to do. The parties have numerous admissions on this point, and I would point the court to admissions 3, 6, 13, and 8, as I've discussed as well. These are points that are not in dispute. All the parties agrees that the GEM system that Pima County uses information that's stored in those MBD files to program memory cards and to accumulate votes on the optical scan and touchscreen devices that those memory cards are inserted into. So when you go to the polling place and you put your ballot in and it scans the ballot, it's being read and processed at that moment. It can't do that without the memory card. And the memory card can't do that without these sensitive files that we're talking about. Now, there's honest disagreement among the expert witnesses as to what a computer program is. And if you're not satisfied necessarily with the admissions, which we think get you to that point already, Dr. King, or Professor King, who is an associate professor of computer science, information systems and management science at Kennesaw State University in Kennesaw, Georgia, will testify that these programs indeed do contain computer programming. And they contain programming as that term is commonly understood in the field of computer science. Certainly, the legislature has the right, of course, to define what a computer program is. And it did so, admittedly, way back in 1979 and 1980 when it authored 16444A4. And it says that a computer program has all programs and documentation adequate to process the ballots at an equivalent counting center. It is our position in the testimony that we will have, plus the admissions that have already been made, plus the deposition testimony excerpts from plaintiff's own experts, that the files that we are talking about meet the 16444A4 definition of a computer program. Because there is no way that you can process ballots at an equivalent counting center without the data and without the programming that's within that .mbd and GBF file. Now they have asserted an argument here for the first time that's a new argument, and I wish to address it just briefly now. They have asserted that documentation doesn't mean the MBD file. First, I think the argument, our position is it contains computer programs, so therefore it's programs, and perhaps we really don't care what documentation means. But in any event, our fallback position would be, no, it's really the documentation as well. They're saying, well, documentation means this thing that's done by part of certification under the federal system. Here's where the argument will fall apart. We've only recently, because of the issues I think probably arising out of the 2000 election, went to the Help America Vote Act, where we really started federalizing in terms of regulation, local regulations. 16442, which he's relying on, was adopted relatively recent to meet that. The statute we're talking about is a very old, well, I'd like not to think it's very old. I went to law school back in 1979. But anyway, it's been around a while. Another point with respect to this argument is that other jurisdictions, and you'll have evidence of tapes, and I think even Mr. Reisner admitted as much, evidence of tapes, evidence of other documents or letters, transmittal letters, I'm trying to say here, from like the city of Tucson. And I urge you to take a look at those transmittal letters. They're key because they're saying, what are they sending up? They're sending up what they call the database, which we call the MBD GBF files, pursuant to 16445, 10 days prior to the election. They're not sending the GEMS executable program and some series of hash totals. And we have a witness from the city of Tucson, Deborah Raynon, who will testify to that fact. We have a witness coming all the way from Globe, Dixie Mundy, who is the elections director in Gila County, will testify to that fact, as well as to other items. So, by any stretch of the imagination, what is required by the statute, a fair reading of the statute, and what is supported by the admissions, which we think are very compelling by the plaintiffs in this case, is that these are computer programs within that statutory definition. Third, agencies and administrators who are charged of enforcing and interpreting statutes, it would be our position that they have something to say in terms of how they practice and what they write and what they do that should inform the court with respect to the statute. And I just mentioned that with the practice of the elections directors. But that is also the practice of the Secretary of State, or the expectation of the Secretary of State. She has authored a procedures manual in which she defines what a computer election program is. Now, at this point, it's very interesting. If you take the Secretary of State's definition of what a computer election program is, and that's in the context of what must be sent to the Secretary of State prior to each election, their experts have conceded, essentially, that it meets that definition. Okay? So I know the court in its previous rulings had some reason not to follow that, and we'll provide additional law to support why you should consider the Secretary of State's definition, but there is no dispute as to this fact. Let's move on to the other public policy reasons here why we think these things should remain confidential, notwithstanding the statutory argument. As I understand the trial, we're going to present evidence as well with regard to the Carlson balancing test. That was the third item that I had mentioned. Here's where we have much agreement, surprisingly. And this, in some sense, may make the trial either shorter, or at least when you go to unravel everything that we said, you'll have some real easy basis upon which to draw some conclusions. There is no question that there are significant flaws with the GEMS software from a security standpoint, not from an accuracy standpoint, but from a security standpoint. Second, the databases themselves are not secure. We know that. And we agree that they can be altered using Microsoft Access. We know that these databases are essential for programming the memory cards of the machines. Why anybody would want to have this kind of insecure software out in the public domain, however, is something that is beyond us. We don't understand. I mean, certainly we understand the need for transparency, but surely there must be a balance for security as well. And the problem here that we have, and I don't think there's any disagreement about this among the experts in some sense, is that, gee, if this software is really that vulnerable, we should get a new system. Well, that might be good in a perfect world, but Judge, neither you, nor me, nor Mr. Reisner, nor anybody in this courtroom right here is going to be able to affect that change. That change is to be effected at the legislature. And indeed, we have testimony from Mr. Paul Eckerstrom in his deposition that the real purpose for this lawsuit is to build public support, which you see all behind you here, for a change of the system. And again, we could all argue about that and think that's a good idea, but we respectfully submit that that's a legislative decision. Our view is this. We will have evidence that the systems with respect to contain user IDs and passwords. Certainly the county hasn't been very careful about user IDs in the past as far as its practice, but we do have encrypted passwords in that database. Revealing the structure of the database, or revealing the database, or disclosing it will reveal the structure. It'll get exactly at what he wanted, the SQL queries as to how everything is set up. He wants the program. They're not satisfied with the results. It will show, even if they're looking at past elections, a series of patterns as to how the county sets up elections. Judge, you're going to hear testimony. This is not an easy process to set up an election in a jurisdiction as big as Pima County. There will be testimony, if necessary, that in the last primary election in 2006, Brian Crane, the much maligned person in this whole thing, had to carefully analyze and come up with 1,700 different ballot styles. Why? Because every precinct is in a jurisdiction, but they may not all be in the same jurisdiction. And when you're dealing with a primary election where you're having a whole bunch of stuff for the Libertarians, for the Republicans, for the Democrats, it's an incredible amount of work. And what elections directors typically do is they use the past database, they'll cannibalize it, get a lot of that information out as far as their coding and setup, and use that going forward. Revealing that database, of course, now at this point, would reveal the coding and different things for races and different things like that. Mr. King will testify as to that issue. we will also testify that there's enough information in there that one might be able to create a ballot. And we know that that's something that doesn't have to happen as an inside job, as Mr. Reisner would like to say. Unfortunately, as part of the history of the Republic, we've had probably instances of where people stuff ballot boxes. That's not a new concept, unfortunately. So the ability to create ballots could be also a security threat. Next, the release of the databases, we think, will allow others also, even if they get them after an election, to create their own results, to cast controversy over the results of a just counted election. And well, what I'd like to say at this point, though, is that there are other types of things that can happen that I'm sure none of us in this room have ever thought up or dreamed up or aware of. The nature of these issues with respect to security breaches in computer systems is that hackers are very imaginative. And again, the more information that is provided in the public domain, because remember, as careful as the Democratic Party may want to be with it, if this court determines, and we don't appeal, that it's a public record, then we're collaterally estopped from giving it to anybody on the street who wants this data. On the other side of the balancing test, if this side we've waited and put on what we think are pretty heavy security issues. The question is, what's happening on their side of the balancing issue, on their side, that will that merits getting this? And our point is, again, that this data that they are seeking, however, will have very little value for the purpose for which he has said he wants it. Because it can be easily manipulated, the bottom line is, in this whole thing, is we're only going to catch stupid people, all right? Because one could also alter audit logs, one could do anything. So we could give them a database if somehow we were corrupt. You know, these things are always amazing to me. I don't understand how we can be simultaneously Machiavellian and stupid at the same time, but I guess there is a possibility. But what we have here, though, is assuming which theory you want to go about, let's take the Machiavellian one, that if we're able to manipulate all this stuff, and it's one guy back in a dark room and he's taking money on the side or whatever to flip elections, okay, is what would we end up giving him? Okay, well, we presume he's not going to be stupid, okay? And what they're going to get is a manicured database of little evidentiary value. The things that Mickey Donahoe and others of the Democratic Party have tried to do in terms of other types of physical transparency issues go much further to ensuring integrity in elections. And in fact, Dr. Ryan will admit that you wouldn't audit a vote count with this data. Because why? It's the same system that produced it. You want an independent audit. And we do in Arizona have an independent audit. We count those pieces of paper that come out, or take a look at those. We take a random sample, we take a look at those, and we see, do those correspond to the date? And therefore, for the purpose of ensuring election integrity, that the vote really, that when people cast a vote in this county, that it really means what they said it means, that system is already in place. And that militates against having to give them these sensitive databases. Indeed, their experts will testify that they've reviewed the events logs, the Windows event logs, and a number of other types of items that we have given. And what they will say is there is no evidence of fraud. There is no evidence that Pima County, the voters, that an election was held in Pima County that did not reflect a true vote of the people. The point is that there's only speculation. There's only innuendo at this point. Our evidence will be, as well, with Mr. Crane, the much maligned computer person here, who's a dedicated county servant who's been doing this job frankly, his name's been dragged through the mud. The point is he's just one guy who's just trying to do his job. And he's done a very good job over these many years. And indeed, the party's own observer, Pat Pecoraro, we've subpoenaed him. He's expected to testify. He's been all part of this logic and accuracy testing procedure. And, this is another thing, too. I forgot to mention this. They're complaining about the Secretary of State's role is somewhat perfunctory. They come down here, okay, they do a rather minimal logic and accuracy type of check. I could give some credence to that point, is that it may not be that detailed. But in Pima County, what we do is we give the parties, and you'll hear testimony about this, we give the parties a number of sample ballots. They can mark them any random way, and they can do their own testing through the machine to make certain that it's reading properly prior to an election. And Pat Pecoraro, he's part of that process. And he's no slouch. He's got a computer background as well, if we need to get to that. With respect to the allegations that you've heard about with respect to Elections Division employees, yes, Brian Crane, there may be some evidence that he took some materials home with him. All right, maybe that's an indictment of the county, not Mr. Crane, for not having a place for him, adequate place to put the stuff. And certainly he didn't want to lose the data. There's no evidence in this case, and indeed, when he was confronted with this vote overwrite situation in the I-Beta thing, and he was dragged through in front of the Attorney General, that I-Beta report, which they did not object to in the joint pretrial statement, basically says no evidence of fraud in this particular case. None. Aspects with respect to people giving summary reports or asking for summary reports, there's no evidence in any way that one, I think it's doubtful that occurred, but to the extent that people may have run summary reports and given them to the Oro Valley town clerk, is there any evidence that affected the outcome of an election? And is there any evidence that could be detected by having these MVD or GBF files? And the answer is no. There will be no evidence of that. In going through all of these points here, and maybe it's a good thing to have a trial on these issues, is that there are innocent explanations. And I think I would take the credibility of Mr. Pecoraro. If he testifies as anticipated in this particular case, he will indicate that since Brad Nelson has become Director of Elections in 2002, the Division of Elections is a much tighter ship than it used to be. Than it used to be back in the days when we had the punch cards and everything else. And that's a good thing. Now, the security changes, their experts will also say that the way to ensure election security is to implement good security. And here we have some agreement. Again, they are indicating that they push the county into doing a number of things, like repositioning the observation window for the computer room, exposing all the wiring that goes to the computer. All of these things are good. I would like to indicate that Dr. Moffat also had a significant role in that as well, too. Those kind of physical security changes are things that our experts will say are really, and actually theirs, will say go a much longer way to ensuring the security of elections and the transparency of elections. Judge, this case is not about what should happen with respect to the machines that we have or anything, because those same experts will tell you right now there is no commercially available machine that is certified. No commercially available machine and software that is certified for use in Arizona that does not have some of these computer security flaws. It's just the era in which we live. We might all agree that that should be developed somehow differently, or it should somehow be rectified in the future, and indeed, that's a good political and a good argument to make to the legislature. But it does not inform this court's decision with respect to whether these files are confidential or not under statute, whether they are public records, or whether they should be released in any event. The county respectfully submits that these records that are being sought should remain confidential. Thank you.
Thank you.